Your Honor.
Yes.
Okay, we're ready. You're being Richard.
All right, Mr. Manning, who do you want to start with first?
Judge, we can begin with Mr. Driscoll.
Darian Driscoll, CR 2417. Show that he is set for pretrial.
Yes, Judge. At this time, we have no contested pretrial issues. Request to be set for docket call.
All right, court sets Mr. Driscoll for docket call November 14th at 1:30. Who's next?
Just next ready on Mr. Dennis Jones.
All right, court calls cause number CR 24167, State of Texas versus Dennis Ray Jones, set for pretrial.
Yes, Judge. We have no contested pretrial matters at this time. Request to be set on docket call.
All right, there being no contested pretrial, court sets docket call November 14th, 2024 at 1:30. And just to note for the record, the court has found Mr. Jones's bail to be insufficient in this cause.
And Judge, what was the basis? Oh, I'm sorry. I remember now.
Not on board. Yep. Yeah, good deal. Well, I was hearing when I was important.
No, it was, yeah, we'll talk about
That's what it was, because that's.
Hold on, just a second. Okay, so you'll sign, right there. And if you'll leave him in. I don't know why you're here. I'll talk about it in a second. Judge, next ready on Mr. Bobby Shaw.
Mr. Shaw. This is cause number CR 24175, State versus Bobby Jean Shaw for pretrial.
Yes, Judge, I believe we were just catching up this case with the other cases. We do not have any contested pretrial issues on this case. We have to be set on docket call.
All right, court finding that there are no contested pretrial motion sets Mr. Shaw for docket call November 14th, 2024 at 1:30. Who would you like next?
Judge, I believe that's all the resets I have ready right now. I do have some paperwork to go over as well as things to communicate with my clients. I know Ms. Abraham said we have a Zoom hearing in about 10 minutes. Is that correct?
Yes, sir. I think we have it scheduled for one. Well, actually, it says 2 o'clock, I believe.
Okay. If I may have until 2 o'clock to discuss some things with my clients, and then I'll take up the Zoom hearing at that point in time.
Yeah, hang on real quick. Let me make sure Henderson County's already in. Yeah, I don't see Henderson County. So, okay, court will stay in a recess until 2 p.m.
Thank you, Judge.
And Your Honor, I apologize. It seems both Mr. Hernandez and I were kicked off for Mr. Shaw before we were able to get back on. I last saw the announcement for, I believe it was Mr. Jones. Yeah,
You said you did see the announcement for Jones, but not for Shaw?
yes, sir.
Yes, Mr. Manning announced that there were no contested pretrial motions on Mr. Shaw, and we set him for docket call November 14th.
Thank you, sir.
Thank you.
You're welcome.
Your Honor.
Yes, ma'am. All right, this is cause number CR 24-75, State of Texas versus Timothy Wade Hubbard. Mr. Hubbard is appearing from the Henderson County Jail on arraignment. Mr. Manning, go ahead.
Judge, I believe this is Mr. Phillips.
Oh, I'm sorry, Mr. Phillips. I'm sorry, Mr. Phillips. Sorry, I didn't see I don't know how Mr. Phillips got into the hearing, so I was kind of confused. I thought maybe this was the 1:30 with Henderson County. Okay, let me flip back over. I'm sorry, Mr. Phillips. This is cause number CR 24-80, State of Texas versus William Howell Phillips III on docket call. Mr. Phillips is appearing from the Kaufman County Jail. Go ahead, Mr. Manning.
Judge, I've had an opportunity to speak to Mr. Phillips' attorney there in Kaufman County. Additionally, I spoke to the state. I have not been able to speak to Mr. Phillips in person since my initial appointment with him in Kaufman County. Judge, before we announce one way or the other on docket call, I would like an additional setting to speak to him, discuss his options both here and the collateral consequences as they would affect his case over there. If I could just have additional reset, I'll go over this next week when I'm over in Kaufman County and visit with him and see where we're at.
Any objection from the state?
No objection to a final docket call, Your Honor.
All right, will November 14th be sufficient?
Yes, Judge.
All right, court sets Mr. Phillips for a final docket call on November 14th at, let's just go ahead and do 2 p.m.
Yes, Judge.
All right, thank you, Mr. Phillips. Mr. Manning will be over to see you, and then we will either bring you here to our court or we'll Zoom you on the 14th. All right?
Yes, sir. Thank you, Your Honor. Have a good day.
You as well, sir. All right, and Mr. Manning, I don't know if you were ready or not. Looks like Henderson County just moved into the waiting room.
Perfect, Judge.
You may go ahead and bring them in from this morning.
That'd be great, Judge. And Judge, I believe this would be an arraignment if we could display the indictment.
think so. I can't hear him.
Mr. Hubbard, can you hear me?
Yes, sir, I sure can.
All right, here we go.
Yeah.
Mr. Hubbard, this is cause number CR 24-75, State of Texas versus Timothy Wade Hubbard. Mr. Hubbard, can you see your attorney, Mr. Manning?
Yes, sir.
Okay, excellent. All right, we are here today on your arraignment on a possession of controlled substance, penalty group 1, greater than 1 grams, less than 4 grams. Mr. Manning, I'm going to go ahead and share my screen for the indictment. Can you see that, Mr. Manning?
Yes, Judge. Mr. Hubbard, is your name spelled correctly?
Yes, sir.
And do you understand you've been charged with a third-degree felony? Range of punishment for a third-degree felony is 2 years up to 10 years and up to a $10,000 fine. You understand that?
Yes, sir.
Okay. And you realize this is the indictment that's been brought forth by the grand jury here in Van Zandt County for the charge, and they're alleging that you possessed, intentionally or knowingly possessed methamphetamines in the amount of 1 gram but less than 4 grams. You understand that?
Yes, sir.
Your Honor, at this time we waive formal requirements of the arraignment. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. We ask to be set on the pretrial docket.
All right, the court enters Mr. Hubbard's plea of not guilty into the record. Court also finds that he waives the formal requirements of arraignment. The court places Mr. Hubbard on the docket for pretrial for November 14th at 2 p.m. That's if he's in custody. If you're not in custody, Mr. Hubbard, if you make bail, then your hearing, if you get transferred back to Van Zandt County, your hearing will be at 1:30. If you make bail, then your hearing will be at 9 a.m. on that same day. Do you understand?
Yes, sir. I'm not gonna make bail. I actually got a pretrial here in Henderson County on October 10th, so I'm gonna be in custody.
Okay, well, if that's the case, then we'll either make arrangements to have you brought to Van Zandt or we'll Zoom you like this again.
Yes, sir.
And Your Honor, just for record purposes and for Mr. Hubbard's purposes, I have received a offer in his case to resolve his case here in Van Zandt County, and I will be seeking to communicate that with him and discuss his options going forward as soon as I can get in contact with Henderson County.
Okay, that is noted. All right, thank you, Mr. Hubbard. We'll see you back on November 14th.
Yes, sir. Thank you.
You're welcome. Tell the jail staff I appreciate their assistance.
Yes, sir.
All right, Mr. Manning, you ready on anyone else?
Judge, I believe we have one more via Zoom from Anderson County.
I think they're 2:30.
Miss Taberham says she believes that's going to be at 2:30.
Yes, I'm not seeing anybody from Henderson in the Zoom waiting.
Yes, Judge. If that's the case, if I may have till 2:30, I will continue speaking to my folks here.
Yes, sir. All right. Court's in recess till 2:30.
Thank you, Judge.
I guess you'll let us. I'm trying to find my.
Good job.
Good thing we're not recording, right? Why is it all top heavy?
Nobody said anything, so I'll give them. Can you ask? I just wondered if it makes a difference. Oh, you may have to say. Your Honor.
Your Honor, I believe we're ready on the 2:30. I will get what I paid for.
Well, we're gonna get the balls out here.
Yeah.
Why not? London said yes. Oh, they can hear better, okay. No, the moment.
My head is hurting right now.
It'll be.
All right, Mr. Manning, I believe that, see who I've got ready in the waiting room.
It was my understanding that Mr. James,
Dennis, yeah, Mr. Dennis is there, so we'll go ahead and bring him in. I was making sure that it wasn't Justin Guyton. Now, Mr. Guyton's also in the Anderson County Jail, right? Oh, this is, okay, I see. Dennis James is, Smith County. I haven't seen Anderson County though.
that would be Mr. Guyton.
Yeah, but I'm just telling Patty, I haven't seen him.
Okay.
I haven't gotten in there. So all right, we'll go and bring in Mr. Dennis.
And Judge will also need a copy of the indictment on this one as well.
I'll show that Mr. Dennis has hooked up the audio yet. There it is. All right, good afternoon, Mr. Dennis. Can you see and hear me okay?
Yes, sir.
Excellent. Can you see your attorney, Mr. Manning?
Yes, sir.
Excellent. Thank you. All right. Thank you, jail staff in Smith County. I do appreciate it. All right. This is cause numbers CR 24-130, CR 24-131, State of Texas versus James Dwayne Dennis. And we are set for arraignment. And Mr. Manning, you asked the court to display the indictments in both causes. Is that correct?
That is correct, Judge.
All right. Let me do that for you at this time. Can you see that, Mr. Dennis?
Yes, sir.
Okay. Does it need to be larger or smaller?
No, sir.
Okay. Go ahead, Mr. Manning.
Mr. Dennis, is your name spelled correctly on these documents?
Yes, sir.
Okay. And you understand that they have two counts or two charges of abandoning or endangering a child. Both of those are state jail felonies, come with a range of punishment of 180 days up to 2 years in the Texas Department of Criminal Justice State Jail Division. You understand that?
Yes, sir.
Okay. And those charges were from a date of offense of August 29th, 2022. And it looks like they were indicted in the June term of 2024. You understand that?
Yes, sir.
Okay. Your Honor, at this time, my client pleads not guilty to the two charges of abandoning, endangering, CR 24-130 and 131. We request to be set on pretrial docket. He understands the range of punishment, the charge against him. And we ask that pretrial docket, we can get discovery and go over that.
All right, court finds that Mr. Dennis, having waived the formal requirements of arraignment, court enters his plea of not guilty into the record in both charges, and the court sets pretrial in this matter on November 14th, 2024 at, we'll just say at 1:30. That may change, depending on if we need to zoom in Mr. Dennis from another jurisdiction. Mr. Manning, I showed that Mr. Dennis is on personal bond in each one of these cases. The court would like to take up the issue of bond unless there's a request by the defendant to withdraw that.
Your Honor, at this point in time, we'd ask that those personal bonds be revoked so he can get credit for time while he's sitting in Smith County.
Court will find Mr. Dennis's personal bonds to be insufficient at this time and will issue new bail based on cash or surety. And I will get that order signed and provided to you and filed with the clerk.
Thank you, Judge.
And Your Honor, there are also a couple other cases with Mr. Dennis, CR 23 -10 and CR 24 -96. They're not on today's docket, but state would ask that those cases be set on the same days.
You know,
And I believe,
go ahead.
I believe there's also a capias in the CR 2310 matter for failure to appear.
Do you know if those are currently set on the court's docket?
I don't believe so, Your Honor, but I'll pull it up just to be sure. The CR 2310 is not set, Your Honor. The CR 2496 has not been set either yet, Your Honor.
Good job.
All right, court sets cause numbers CR 2310, CR 2496, both also on November 14th, 24 at 1:30 to run with these other two cases. Thank you, Mr. Hartwell. I appreciate that.
Yes, sir.
All right, Mr. Dennis, if you finalize your business in Smith County, I'm sure we'll have you back over here in Van Zandt. If you don't, we'll make contact with Smith County and see if we can Zoom you again on November 14th, okay?
Well, I've already finished everything with Smith County. I've been waiting on you guys for almost 2 months now.
You've already resolved your Smith County cases?
Yes, sir. I mean, I'm due to get the chain to TDC any day now.
Okay, well, I appreciate that information. I will get with my coordinator in the state and determine if we want to get you bench warranted over from Smith County, or make sure that we might not even have had a retainer on you. If the capias was still, that capias warrant was still active and it wasn't placed on you, then we don't have a detainer. So let us see if we can get that done, and then we'll get you brought back over to Van Zandt.
Okay, Mr. Manning,
Yes, sir.
I was looking to sign today to get this over with and done.
Yes, sir. We need to have you back here before we can do that. Judge needs you here in the courtroom or here at the jail for us to do that.
And Mr. Manning, if it works out that Mr. Dennis wants to come back sooner than the 14th, then let us know. And of course, we've got some other dates here in a couple of weeks. We got dates all throughout October. If we need to do it sooner, we can. Just let us know.
Judge, as soon as he hits our jail, I'll be meet with him and get something set up.
All right, Mr. Dennis, we'll make arrangements to get the detainer put on you and get you transferred back to Van Zandt so that you can meet with Mr. Manning in person. You can go over all the discovery in your cases and see if y'all can reach some kind of agreement with the state, okay? It's just gonna take a little bit more time.
Okay.
All right, then we'll, at the very least, we'll see you on November 14th, if not sooner.
All right.
All right, thank you, sir. Have a good day. All right, who would you like next?
Judge, ready on Mr. Marcus Gibson.
Marcus Lynn Gibson, CR 2498, CR 24-134. I believe that the 134 case is for pretrial, 98 is for docket call. Go ahead.
Yes, Judge. Today, I received a new offer from Mr. Gibson. He accepts that offer and requests to be set at the next docket setting to resolve both his cases.
You want to set that on October 17th?
Yes, Judge, that'll work.
All right, court sets Mr. Gibson for plea, and this is in both cases, Mr. Manning?
Yes, Judge.
All right, court sets each case for plea on October 17th at 1:30.
Thank you, Judge.
Who would you like next?
Next, Judge, we're ready on Mr. Garrett Jocelyn.
Garrett Lee Joslin, CR 2486, CR 24169. Show that we're set for pretrial in each case.
Yes, Judge. There was a plea deadline for Mr. Jocelyn to accept the state's offer by today. He does accept the offer and requests that he be set on the same docket as Mr. Gibson, that October 17th docket.
All right, court sets Mr. Joslin to enter his plea before the court October 17th at 1:30.
Judge, next ready on Mr. Campbell.
Robert Baker Campbell, CR 19108. Go ahead, Mr. Manning.
Judge, we have a motion to withdraw the state's motion to adjudicate guilt, as well as an amendment for probation for Mr. Campbell to attend the Prodigal's Home Discipleship Center up in Rusk County. He has been accepted to that program. We have a letter of acceptance and have forwarded all those documents to the probation department, and they've approved of that placement. He will be heading there directly from his release today. I spoke to the home director for that program, and they are ready and willing to take Mr. Campbell as soon as he gets there.
Give me some more information about what this program consists of, how he gets there, how he pays for it. Is there a cost? Because I have concerns that if Mr. Campbell has to put forth any effort, he's going to fail.
Yes, Judge. So I was part of the reason I was a little bit late getting on today was I was on the phone and receiving information from the program. So the first phase, they're going to establish boundaries and learning routines while in the house, living day-to-day life, substance-free. They're going to be going through book studies and Bible studies, as well as learning how to use carpentry and trade skills around the shop and build on skills that they already have. They'll have established daily routines that involve work, study, and assisting with on-site work. Then after they get through that first, they also will be doing classes. So they offer Celebrate Recovery, GED classes, Reef Share classes, and other classes that will be a part of their program curriculum. After they finish that first 3 months, then they will then be providing in phase 2, providing for their stay by going out and working. They'll begin building up finances, learning how to administer those properly, do a budget, preparing for release. And then phase 3, they will begin obtaining their documentation, make sure their ID or driver's license is correct, begin planning for the exit process, begin looking for local churches, sobriety meetings, resources. If they are still having difficulty finding housing, Then they'll go through financial classes and continue financial classes from phase 2. They'll begin speaking in at the center as well as other places about the work that they've done. Begin rebuilding rapport with their communities that they'll be released into, and then phase 4 is those last 2 months. They'll begin the they'll finalize the exit interview, look at long-term planning, and finish up their coursework. They have a book list that's about 10 different books involving different issues for men. And then in speaking to my client, one of the reasons why he is willing to go into this program is he has seen veterans in his situation. He's seen the change and results from their lives, getting their lives turned around. It is a longer program. It's a 12-month program. And so he recognizes that may be the type of system that he needs to get his life back on track and be able to live as a productive member of society.
So this place is going to provide him housing and food and.
Yes, Judge. He will be living on campus, and any transportation needs that they have to make probation appointments or community service, that will be provided by the campus and be coordinated through them. And looking at some of the materials also, as I said, they will have an opportunity to actually earn their own money as they get later in the phases, begin building up a nest egg so that when they do get out, they're not being turned back onto the streets to scrounge, but they will have some money they can put towards renting a home or providing a vehicle. Mr. Campbell has assured me he does have transportation to get up there. And so he will be able to get there as soon as we get him processed out and released.
All right, Mr. Campbell, this is it.
Yes, sir.
This is the end of the road for you,
Yes, sir.
for you and me. This is it right here.
Yes, sir.
Last chance I'm going to give you. I've been over backwards during sanctions court to try to get to know you, to try to understand your circumstances, to try to work with you. I gave you a lot of grace. I gave you a lot of slack. So this is it. This is
Yes,
the
sir.
last time I'm going to give you an opportunity. If you violate, if you get another violation, then I want the state to just file their motion and we're going to have the hearing. And
Yes,
that's
sir.
it. There will be no more efforts put forth by you to go somewhere else or get another chance. You understand?
Yes, sir.
All right. Court will grant the motion to withdraw the state's motion to adjudicate. Court will approve Mr. Campbell's continuing on community supervision, will amend his conditions to include the participation. And what was the name of this facility, Mr. Manning?
Judge, is the Prodigal's Home Discipleship Center in Rusk County.
Prodigal's Home and Discipleship Center.
Correct.
All right, court makes that a condition of his community supervision. All right, Mr. Campbell, don't screw it up.
Yes, sir.
You've stopped the expired sections.
Judge, one concern that was just brought up is we may need to extend Mr. Campbell for a period of time depending on how much time he has left on probation. So Ms. Burns is going to look at that, and if need be, we may send a. She's saying that she shows that he expires September 30th of 2025.
How long is this program? It's a 12-month program?
12-month program, so,
Then we need to do the extension today while we have him on the record.
yes, Judge.
So Mr. Campbell, just go ahead and have a seat and we're gonna get some paperwork done. Come on back up, Mr. Campbell. Let me talk to you about a couple of things. So in order to be on this program, it's gonna take a minimum 1 year and you're set to expire on your community supervision in September of this year. I mean, September of next year. So that means that if it's a minimum 12 months, you would not be able to successfully complete it within the time frame needed. So we're gonna need to either extend your community supervision or you're not gonna go to this program. So if you want to go to the program,
Yes,
we're,
sir.
we're gonna need a minimum of probably 6 months extension. Is that what you would say, Ms. Burns? 6
Yes,
months?
sir. Yes, sir.
So, Mr. Campbell, do you want the court to extend your original probation period for 6 months to allow you to go to the Prodigal Homes and Discipleship Center?
Yes, sir.
All right, court will grant the amendment of the community supervision conditions for an extended period of 6 months. Ms. Burns, do you know what would be his new expiration date?
It would be September 30th, or, I'm sorry, hang on. March 30th, 2026.
All right, that's gonna be your new expiration period on probation.
Yes, sir.
And
All right.
Judge, Ms. Burns is putting out an amendment and we'll have him sign that before he leaves today.
Excellent. Thank you, Mr. Manning. All right.
Thank you.
You're welcome.
Yeah, you just have him submit. Judge, if I may, I still working on, the last of our plea paperwork. So if
Sure.
I may have just a couple more minutes, it's been a bit crazy over here. I apologize.
Sure. Court will stand in recess. Let me know when you're ready.
Thank you. Do we have an idea, Mr. Guy? Okay, we're live.
Your Honor,
Yes, ma'am.
we are ready.
All right, I need about 2 or 3 minutes. I'm working with Estelle on an issue.
Okay.
All right, Mr. Manning, I'm ready. Who would you like to call first?
Judge, if we want to, we can start with Mr. Del Cambry.
All right, Mark Del Cambry, cause number 2. CR 24-4. See, I don't think I have. Let's see. I don't think I have. At all, to Mr. Del Cambry. So
Okay, Judge, I can fill you in.
first of all, is it an indictment? It is, correct?
Yes, Judge. The CR 24-4. And it was originally charged, I believe, as a,
Injury to elderly,
yes, Judge.
3rd degree.
Yes. We're
Okay.
proceeding under a lesser included assault causing bodily injury family member. And the punishment's gonna be assessed at 338 days in county jail with credit for time served. family violence fine of $100, a lifetime protective order, and court cost of $290 with reimbursement of $520.
No weapon disposition or anything like that, right?
No, Judge, and actually on that, on the manner and means, the stipulation, I've spoken to the state and we've agreed to modify the stipulation as interlineated. It's going to say, I can show it to you here in a second if you want.
Yeah, just show it to me at the requisite time. All right, this is cause number CR 24-00004. State of Texas versus Mark Lane Del Camry. Mr. Del Camry, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, sir, you can lower your hand. Mr. Del Camry, are you a United States citizen who reads, writes, and speaks English?
yes, sir.
Have you ever been diagnosed with a mental condition?
No,
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you?
yes, sir.
Do you understand everything that you have read and signed today that's part of your plea agreement?
Yes, sir.
Do you have any questions about anything before we go further?
No,
Mr. Manning, do you believe Mr. Del Camry to be competent? And if so, have you explained to him his rights about this case? And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
Judge, I believe he is competent. He's had the opportunity to discuss multiple aspects of his case. I do believe he's entering into this plea intentionally, and only voluntarily.
All right, Mr. Del Camry, you were originally charged with a third-degree felony offense of injury to an elderly, but Mr. Manning has stated that you have reached an agreement with the DA's office in which the DA's office is recommending that the court allow them to proceed on a lesser included offense of assault causes bodily injury, family violence, a Class A misdemeanor, which carries a range of punishment of not more than 365 days and a possible fine not to exceed $4,000. You've heard the agreement that Mr. Manning read into the record. Is that correct?
yes, sir.
And is that the agreement you're wanting the court to approve today?
Yes,
All right, I'm going to ask you at this time, Mr. Del Cambre, how do you plead to assault causes bodily injury of a family member?
guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as amended.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state has been in contact with the victim and he was supportive of this plea with that condition of the protective order.
All right. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, back that out just a little bit. Let me see if I can get that to focus. There we go. All right, thank you. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant. The court will follow the plea agreement. Court and the recommendation of the DA's office. The court hereby convicts Mark Lane Del Cambre of Class A misdemeanor assault causes bodily injury, family violence, assesses punishment at 338 days confinement in the Van Zandt County Jail, awards him 338 days of time served. The court orders him to pay a $100 family violence fee. The court orders him to pay court costs of $290 and reimbursement fees of $520. In addition, the court finds that an application for protective order has been filed in cause number FM 24-00371. Court finds that Mr. Del Cambre has agreed to the issuance of a lifetime protective order, and the court approves that protective order as well. All right, Mr. Del Cambre, If you are unable to pay all of your fines, court costs, and fees today upon being released or within the next few days after being released, if you need a payment plan, then you need to go to the district clerk's office and talk to them about a payment plan. Mr. Manning.
Yes, Judge. Mr. Del Camry has a out-of-state hold, so he will not be released from incarceration today. I've explained to him the process of once he is released from incarceration to set up a payment plan, and he understands that process as well.
Okay. And Mr. Manning, was a copy of the protective order produced to you for his signature?
It was not, Judge. I would ask if they would just serve a copy of that on Mr. Del Camry here at the jail per usual, so that he has a signed copy for his records.
All right, court will issue the protective order and I will have a copy served on Mr. Dale Cambray at the Van Zandt County Jail.
Thank you, Judge.
All right, if there's nothing further in this case, then we are adjourned in this case. Good luck, Mr. Dale Cambray.
Thank you. Judge, next ready on Mr. Wheeler.
This is cause number CR 24-229, State of Texas versus Charlie Edgar Leroy Wheeler for arraignment. Are we
Judge.
all set for plea?
Yes, Judge, you have the paperwork?
No, sir, I have no paperwork.
Okay, Judge, we're also taking up 2017-152. The state has filed a 1245 admission of unadjudicated offense and motion to dismiss. That is a burglary of a vehicle, and it's going to be taken into consideration with CR 24-229. Judge, we've also signed and filed a waiver of indictment. This case is going to be proceeding on information. The terms are that the date of offense was September 9th, 2024. The charge with which he's going to be convicted is possession of controlled substance. Penalty group 1 to 4 grams. Upon a plea of guilty, punishments to be assessed at 4 years TDCJ institutional division with a $750 fine and $180 restitution.
Court costs
$290,
and jail time.
24 days.
All right, anything further?
Judge, this is set to run concurrently with any and all other issues. And there's a $15 reimbursement fee in addition to the other financial obligations.
All right, very well. Mr. Wheeler, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony that you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Good lower your hand. All right, Mr. Wheeler, is your name Charlie Edgar Leroy Wheeler?
Yes, sir.
And Mr. Wheeler, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you?
Very much so, sir.
Do you have any questions about anything before we go further? And you gotta say yes, okay.
No, sir. Sorry.
And you've taken the time to read over your plea papers. You understand everything that you've read and signed, correct?
Yeah, I do.
All right. Mr. Manning, do you believe Mr. Wheeler to be competent today?
He is.
And you've explained to him his rights as they pertain to this case?
I have.
All right, Mr. Wheeler, you are charged by information with the offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. That is a felony offense, and before any individual in Texas can be charged with a felony offense, one of two things has to happen. Either they have to be indicted by a grand jury, and a grand jury has to hear evidence and determine if there's enough evidence to go forward with a prosecution, or an individual can waive their case being taken to the grand jury and waive the issuance of an indictment. Mr. Manning has told me that you wish to waive your right to an indictment. Is that correct?
Yes, sir, I did.
And you understand that by waiving your right to an indictment, you're allowing the state to prosecute you for a felony without taking the case to the grand jury.
Yes, sir.
And has anybody threatened, forced, or pressured you to waive your right to a grand jury?
I have not, sir.
Okay, and if I approve this plea agreement, you understand that the right to to a grand jury, you're not going to be able to get that if you change your mind later. If you go down to prison and you change your mind and decide you want a grand jury, you understand that that right will have been waived.
Yes, sir. I'm guilty, sir.
Okay, well, we're going to get to that part in just a second.
I'm sorry.
So I appreciate that, but I just have to go through some what we call legal admonishments.
I apologize.
All right, so the court is going to find that Mr. Wheeler has intentionally, knowingly, and voluntarily waived his right to an indictment in this matter. All right, Mr. Wheeler, you also understand that the range of punishment for this type of offense is not less than 2 years in prison or more than 10 years in prison, and you could receive a fine not to exceed $10,000. You understand that is the legal range.
Yes, sir.
Now, you've heard that the agreement you've reached with the state that Mr. Manning has read into the record. You understand that plea agreement, and that's what you're asking the court to approve today. Is that correct?
Yes, sir.
All right. Then understanding all of that, this is that time that I'm going to ask you, Mr. Wheeler, how do you plead to possession of a controlled substance in penalty group 1 between 1 grams and 4 grams?
Guilty, Your Honor.
Are you pleading guilty, Mr. Wheeler, because you are in fact guilty of committing that crime?
Yes, sir, I am.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, thank you, Mr. Wheeler. The court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No, Judge, there's also a slight amendment on this one as well, but I have spoken to the state and they're in agreement with that amendment.
All right, stipulation of evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Nothing further, Judge.
All right, Mr. Manning, if you would assist the court with a stipulation. All right, thank you, Mr. Manning. I appreciate it. All right, the court, having read the stipulation of evidence, considered the evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court does follow the recommendation of the DA's office. The court hereby convicts Charlie Edgar Leroy Wheeler of possession of a controlled substance in penalty group 1 between 1 gram and 4 grams. Mr. Manning, before I go further, did the stipulation recite the amount of methamphetamine?
Yes, Judge, it stipulated that he was the DPS, well, the DPS lab has tested it. They did not return a analysis, but it does weigh, the methamphetamines did weigh between 1 and 4 grams.
Okay, is that included in the stipulation?
Yes, Judge, it's the last line.
Okay, thank you. All right, then the court assesses punishment pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice, orders the defendant to pay a $750 fine, $180 restitution, $15 in reimbursement fees, $290 in court costs. The court awards Mr. Wheeler 24 days credit towards his sentence for the time that he's already spent in jail on this case. Court orders this sentence to run concurrent with any other sentences that Mr. Wheeler may be serving. In addition, the court does dismiss under section 1245, cause number 2017-152, a burglary of a vehicle. Mr. Wheeler, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck to you, sir.
Thank you, sir.
Who's next?
Go ahead. Judge, if next, if we can call up Mr. Tatum, and if we can go off the record briefly to discuss a couple things.
Yes, this is cause number CR 24151, CR 24152, State of Texas versus James Terry Tatum, and the court will go off the record at this time. Hang on, Mr. Do you want to go to a breakout room?
No, Judge.
Okay. All right, go ahead, Mr. Green.
Judge, my understanding after our last court setting was that there was going to be an order for evaluation done regarding Mr. Tatum. We have been unable to verify whether that's happened or not due to some of the technical issues that are going on today. And so I'm not sure as the announcement to make regarding Mr. Tatum's status, whether he's still waiting to be evaluated or if he has been ordered to be evaluated at this point in time.
I've had some discussions with Ms. Tabraham this afternoon. It was my recollection that we had, but however, I cannot find an order to that fact. So let's reset him for November 14th. If we can't find an order, then we'll go ahead and order that competency evaluation with Dr.
Yes, Judge, and I will convey that information to my client. If we can, before we go back on the record, if I just have a moment, I'll mute and speak to Mr. Tatum.
Yes, sir. Go ahead. Go ahead, Mr. Manning. You want this on the record?
Yes, please.
All right, we're back on the record. Go ahead.
Judge, I've explained to Mr. Tatum that we are still awaiting the doctor to come and visit him regarding the competency procedure. I told him that the court is going to be resetting his case to November 14th, and he said that he understands that and is willing to wait on that process.
All right, thank you. All right, Mr. Tatum, then I'll send Dr. Ingram to see you very soon, okay?
Yes, sir.
All right, thank you, Mr. Tatum.
Yeah, they're just right here. Tatum? Here's your. Judge, while we're waiting on getting Ms. Zentner in here, I see that we have three remaining that are out of county. Justin Guyton, Joseph Parks, and Kelly Pickett.
Okay, yeah, let's go ahead. We'll start with Mr. Parks. Court calls cause number CR 22192, State of Texas versus Joseph Leon Parks. Motion to revoke. Court has confirmed that he is in the Hunt County Jail. Court will reset this for November 14th. And I'll work with Patty on seeing if we can't get some kind of Zoom set up or find out more information about if we have a hold and or how much longer he may be in Hunt County.
Yes, Judge. Next, we have Mr. Guyton.
Court calls cause number CR 24-54, State versus Justin Dramel Guyton, set for pretrial. We do show that he was in Anderson County. I believe Ms. Taperham set that up for him to appear via Zoom. However, I've not seen him enter into the Zoom waiting room. Court recesses pretrial to November 14th, and we'll make contact again. If need be, Mr. Manning, I may, I tell you what, because this is a pretrial hearing, and I believe that the offense date was in August and he got indicted in March. I'll tell you what, let's set this October 17th. I'd rather it be sooner than later, and let us try to get the Zoom lined up again.
That was Mr. Guyton.
Guyton, yes, Justin Guyton. And then lastly, the court calls cause number CR 24-185, State versus Kelly C. Pickett for arraignment. Court finds that I don't know if that's a guy or a girl. Do you know, Mr. Manning?
I believe that's a male.
All right, Mr. Pickett is in the Ferguson unit of TDC. And so state, your indictment is for aggravated assault with a deadly weapon. Are you wanting the court to issue a bench warrant to return Mr. Pickett?
Your Honor, if I could have just a moment
Yes, sir, go ahead.
Your Honor, if I could get the court an answer in a little bit. Talk with the other prosecutors in the office and see how they feel about going forward on this one. I'd appreciate.
Yes.
Thank you, sir.
Well, I'll tell you what, let's do this. Let's do this, Mr. Hartwell. I'll give you more time. Let's reset this for arraignment on October 17th. And you can let us know, either tomorrow or next week. And if we need to do a bench warrant, we may have time to get them in.
Thank you, sir.
You're welcome. All right. And so you're waiting on Ms. Zutner, correct?
Ms. Zutner is here present.
All right. Do you need that indictment, Mr. Manning, or do you have that?
Yes, please, Judge.
Need it? Okay. Get that.
I was, when I last checked, Ms. Zutner was not here present, so I've not had a chance to talk to her since our initial meeting. Okay, so we're here on the arraignment. So the judges explain the charge. So it spells it. Yes. The charge of 30 debating the rest. Nothing else to make about 2 years up to 10,000. It's like they're saying it's happening about January 16th. No. Discuss. Your Honor, my client's name is spelled correctly. She understands the charge against her as well as the range of punishment. At this time, we request, she pleads not guilty and requests to be set on the pretrial docket.
All right. Court enters Ms. Zutner's plea of not guilty into the record, finds that she has waived the formal requirements of arraignment. Court sets this matter for pretrial hearing on November 14th at 1:30.
So I'll stay here. You tell me important business. Thank you. I dreamed Dallas, but also when I talked to them, I saw my clients running. And so I'm hoping they can put it together. Okay. I'll try to gather some. That'd be great. Also, you spoke with Dr. Yeah, they gave the content. Okay. How did that go? It went well, I think. Okay. You don't have the results for that? I do have the results for that. Okay, thank you.
Is that all you have?
I'm sorry?
Is that all you have?
I believe that concludes my business. May I be excused?
Yes. Thank you, Mr. Manning. Appreciate your work today.
Thank you, Judge.
Mr. Hartwell, Mr. Hernandez, appreciate your work as well. Y'all have a good afternoon.
Thank you, sir. You too.
Thank you very much, Judge. Appreciate it. Have a good afternoon.
You're